Erica Williams, she's in custody.
She is. Take a second.
Good morning. You're Miss Arvin. Nice to meet you in person.
Hey, Your Honor, there was some confusion on whether Ms. Williams had gotten here yet or not, but I just realized she was here to confirm that Ms. Arvin spoken to Ms. Williams. She's prepared to speak to Ms. Arvin. I don't know if Ms. Arvin is going to speak directly with her or maybe arrange for somebody.
She gets back to the jail, I'll have permission to call over.
Okay.
And anyway, I'm just pretty much with his board, and I tell him when hopefully, because I know she needs to see everyone, I'm going to let you guys know.
So for the moment, I think the best thing we could do would be to set this matter for next Friday. I'm not going to be here Tuesday, but I will be here Friday.
Well, and I would be, because we've done this on some of the others, if she's assessed and they think she's appropriate for treatment, I would be willing to enter an order that she be transferred there if that's agreeable.
I've spoken to her. I think she is agreeable with that. We spoke briefly in the back. Well,
You're looking at 6 months. That doesn't make any sense. Just like the last gentleman, that doesn't make any sense.
I would like to at least, my advice to her would be not to enter a guilty plea at this time. At least give us a week to try to figure things out. If at the end of that, that's her decision. I work for her. As long as something to do isn't illegal, I'm going to do what something to do.
Well, that is, she's competent to make that decision, and I think there's an issue on the record as whether she's even competent to make that decision.
No, there is that as well. So I would ask for a continuance for 1 week.
We'll set it for a pretrial next Friday, but I just put it out there that it is possible that if she would go to treatment, it can happen before then.
And I'm going to ask her that happens if she's agreeable.
Yes.
I'll speak to her again. As well.
As of now, October 17th for a pretrial. It was set for the 14th, and Mr. Steyer's not available.
Thank you.
You're welcome.
State of Ohio versus Dylan Adair, case number CRB 25609.
So we've done the assessment. So I think the clinical.
So I'm going to do the same, to back in the jail, I'm going to have the shop patient call over and do what we did in the previous one, that she said it meets criteria. We could get a trip court order to have him brought over, and then I told him on their real work on what it looks like next for him, just like we did for the other one, whether that be treatment options or what we can do to try to get it some, it's almost from what I can gather. So we will try to get him into something secondary.
And is he agreeable?
Yeah, that's correct.
All right, so I'll do an order if he's assessed and is recommended for treatment at Bellefonte.
What time does it take to get back over to the jail?
Well, whenever court's over and we're finished with them, then they can leave, so it'll be this afternoon. Should be early afternoon, they should be back.
Okay, I'll be there and I'll keep you guys updated.
Thank you. So do you want to just go ahead and set another pretrial in case
Yes.
it doesn't happen? What's your availability?
I think it's the 14th.
Okay, so we'll put it on the 17th.
Yes.
Okay, Mr. Adair's next hearing will be the 17th, and like the last case, I can do an order allowing him to go to Bellefonte for treatment if they deem it necessary or appropriate.
There's orders
Yes,
afterwards, you don't want me to type anything.
well, we use the same one we did for J.B. Moore. Oh, Missy did it. Okay, there's one that's,
I'm in the dark on this. You're on
okay,
the-
there's one, there's been an order prepared, so we got one that's, just needs to be modified.
State of Ohio revolves state training. Case number CRA 25-619, CRA 25-621, A and B.
Mr. Stratton's case,
Sorry, can I say-
25-619, 25-621. The 619 is the issue, that's the parole violation, actually, not probation violation out of Kentucky. And there's a holder on that. He's willing to waive extradition to go to Kentucky.
We'll waive extradition to Kentucky, I understand the state law dismisses it.
Well, it can't be dismissed, it's just gonna be held until he's either transferred to Kentucky or, all the felonies, yes. Those are, well, they're gonna be nominal to the agreement. Okay. So the intention of the court is that the holder from the parole violation in Kentucky is gonna stay in place.
Yes,
That he's giving up the right to hearing to determine whether he should go to Kentucky or not. He's agreeing to go to Kentucky.
he is.
So I'm gonna leave it, normally we would notify Kentucky to come pick him up, but I'm not gonna do that now. I'm gonna leave it to Judge Ballard, or one of the common pleas judges, I don't know which judge, to make that call. Okay. All right, the 25-621 A and B are Molly to the grand jury. 25-619 is waived, and it'll go to common pleas.
Yes, Your Honor, I mean, if he's released, then we can hold him to Kentucky to come and get him. As for being released, if they don't come and get him, that's what that's about.
Okay. Well, I'm not gonna make that call, but he's waiving his right to hearing to determine whether he should go to Kentucky.
Right, yeah, so.
State of Ohio recalls Emily Smith here at the court. Case number CRB 23-627. Emily Smith here at the court.
So, Your Honor, I had spoken with
Source.
CoSource, and she had completed on October 7th. Huh? She's a star? Okay, well, there you go.
I didn't see you. You must have came late.
I'm not looking for it, but I talked to.
Oh, did you? Okay,
Sorry.
all right. And she's a star, Your Honor.
All right, so apparently she's got something from our common pleas court. What's the state want to do with this?
Well, this is
It's an old case, and
23 theft charge and disorderly conduct.
I just had one charge. It's complicity to commit theft.
She pled guilty already, and been going through treatment.
She's a star, Your Honor. She's going to be under common pleas probation when she leaves.
I'm fine if you want to acknowledge it.
Yeah, I
The
think
whole
that's-
idea was getting her into treatment. She's been multiple times. This is, and she's had problems with treatment.
Yes, actually, it was the more recent charges that ended up in common pleas, and that's why she's a star. So, yeah, we would agree to nolly everything that's pending.
All right. Matters here are nolly because she's in star and under the supervision of common policeman. So Emily Smith, they're on nolly 23,627.
State of Ohio versus James McClaskey on recall, case number TRC 19975 A, B, and C.
All right, Mr. Klasky's at amended reads, and we're going to give a report.
Your Honor, it's maybe recalled, he said it was sent to Mr.
Can
Mayor.
you give me a verbal?
Yes, he's been non-compliant in this last drug screen, so.
Okay, well, I'm going to need it then. So we'll recall, go ahead and give me the written report.
Would you like him to drug screen today, Your Honor?
Yeah, let's do it. Bring it down.
Yeah, that's helpful.
So go to prosecution to drug screen.
Yeah, that's helpful, my cousin. Forward him to get some money to pay him, but yeah, you can go see.
Okay, we'll do a drug screen.
State of Ohio recalls Garrett Lee Hosey, case number TRB 25546.
I've seen the results, Your Honor. The alcohol and THC speak for themselves, probably. My understanding is there was a test for amphetamines. Mr. Posey has informed me that he takes Adderall and has for a long period of time. That's consistent with my understanding of his mental health treatment that he's undergone up to this point. Now, he spoke to, who are you going to again? Hometown? Lawrence County Recovery.
Yes, I just called.
Lawrence County Recovery, and they have made a new appointment for him. What day is that?
Monday.
For Monday. I would ask if we could set this thing back for next Friday and see if he's gotten himself straight with the provider. Now, if I recognize that if the court does this, we're going to want to see that he went, completed the evaluation, did anything in the meantime they told him to do.
And the other thing you need to make them aware of is they tested positive for THC and alcohol. And I'm going to go out on a limb here and say that if you read the instructions or the booklet that comes with Adderall, it probably says you're not allowed to drink alcohol or you're taking the Adderall. It's contraindicated. So, reschedule this for October 17th for pretrial, 10 o'clock.
You can't leave this time. You've got to stay and do the assessment. Good. Well, you still have to be there anyway. Be here anyway. Thank you, Your Honor.
You are.
State of Ohio versus Adam Searles, case number CRB 25646, A and B. Set for arraignment.
That is our new charge. Adam Searles.
Yes.
Yeah, we don't have it. Sir, are you Adam C. Searles?
Yes.
Okay, we do that. Okay, we'll call, there's a opinion, we'll call.
State of Ohio versus Colby Searles, case number CRB 25645.
She's got a file too.
And ma'am, you're Courtney Searles.
Yes.
And it looks like you're both charged with domestic violence. The complaints alleged on October the 6th this year, Rome Township, you knowingly caused or tried to cause physical harm to each other, and that you're members of the same family or household. That makes it a domestic violence charge, maximum penalty 6 months in jail, $1,000 fine. And then, Mr. Searles, he also has another charge. That's the only charge for you, ma'am. So for Mr. Searles, he's also charged with disorderly conduct. That at the same time and place, he caused inconvenience, annoyance, alarm to others by engaging in fighting, threatening to do harm to other persons or their property, being violent or turbulent, and this was committed in the presence of a law enforcement officer and persisted in after being warned to stop. So that's a 4th degree misdemeanor disorderly conduct. Maximum penalty for that's 30 days in jail, $250 fine. Do you each understand the charges?
Yes.
Do you understand the rights defendants have? I explained it at the beginning of court.
Yes.
Mr. Searle,
Yes, I understand the rights.
how do you each wish to plead to the charge?
Not guilty.
Not guilty.
Do you wish to be considered for court-appointed lawyers?
No, I'm in the process of hiring Mark McCown.
Mr. McCown,
Yes.
what about you, ma'am?
I need to be appointed a lawyer if possible.
Okay, are you working?
Yes, but I've only worked for a month and a half.
What do you do?
I work for Macon Construction.
Are you paid by the hour?
Yes.
How much per hour?
$15.
How many hours a week?
40.
How many kids? Do you have kids?
I have 3.
Okay, you're eligible. I'll appoint Mr. Steyer to represent you.
Your Honor,
Yes.
can I ask a question?
Yes.
My husband has been holding my personal property in our marital home, and because we have no contact, I have not been able to retrieve any of my personal hygiene, my feminine personal hygiene. I haven't been able to get any of my government documents that are locked in a fire safe. Is there any way that I can get a court order to have someone go up there with me so I can retrieve my things?
We may be able to handle that
Okay.
here in just a second.
They both have bonds up for Mr. Salaries.
Have you hired Mr. McCown yet, or are you simply speaking to him?
I have him for the divorce, but he's supposed to, his dad passed away last week.
Right, that's, well, yeah.
So I paid him retainer for the divorce, and he's going to represent me on this also.
Okay, I can arrange with Mr. McCown for you to do the bonds.
Okay, how soon? Because
I don't know how soon, but I can do it as
Okay,
quickly as I
I don't even
can.
have my medication.
I understand.
Okay.
Okay,
I think we can deal with that through Mr. McCown's office, probably.
all right. It sounds like, is there protection orders requested from each of you to stay away from
For the
you?
moment, mutual protective orders may be a good idea.
All right, so I'll order you both to stay away from the other. Don't go around, don't contact, and don't post things on social media about each other.
May I ask another question?
Ask me.
Probably should ask Mr. Stein.
She's got to sign hers. You can sign her date or
I have a legal question. I don't know if I can get like an attorney that's temporarily into Mark's here.
Yes, can you do that?
Great. Would you be agreeable to dropping the mutual protective orders if she was agreeable to that?
Can I get like a temporary attorney? Because I have, there's,
I can't give you a temporary.
because Mark McCown's not here and I don't want to agree to anything, you know.
Well, if you want to go call him, I can recall it.
Well, let's do that. That'll give me a chance to speak to her off the mic. And
Sure.
so-
All right, and maybe we can resolve some of these issues about property.
Yeah, we can. Thank you.
All right, these cases will both be recalled later in the document.
State of Ohio recalls James Bojaski, case number TRC 19975, A, B, and C.
Do we have a,
So he hasn't done anything.
I called on my last appointment, which was Tuesday, because I was helping my cousin put a laminate floor down to get some money to pay this off.
so I believe his screen was fine today, Your Honor. So-
THC.
Okay. It is set for sentencing?
Yes. He's supposed to be going to amended reads for some counseling, and they're saying he's not participating.
I missed the last one because I was helping my cousin put a laminate floor down so I could get some money to make my payments here and pay some bills.
Well, they're saying.
And
he hasn't
I
been
called
in.
them and they said it was fine. I called him that morning before my appointment. And I didn't know that I could go in there after hours to do the drug test, or I would have, because I ain't dirty on nothing.
Is Ms. Priest still willing to work with him?
Yes, we will work with him.
Okay. Get it done, and you got community service to do and fines and court costs to pay.
That's what
You got
they,
36 hours.
I'm supposed to get paid this evening, and I'll drop some money off, probably it'll be money.
You gotta do community
I think I can do it
service.
over the line, can't I?
I'm sorry?
I can pay over the phone?
No, you can pay on a computer, or you can have to come in person. You can't
Oh, okay.
all internet. You got a smartphone, you can go on there.
No, I got a dumb one.
Okay. Well, everybody's got a smartphone now. Get a 12-year-old, it probably looks like it is a smartphone. Find a 12-year-old and they'll show you how to get on the court's website and make a payment.
My niece could do it.
Then, you got 36 hours of community service still.
Yeah, and Kincaid's supposed to look, because he said some of the hours that I did down there, they think they put them on my son's case down there because of the last name. But he's supposed to check and see for sure, but
Okay, well, keep after it, get it, you know, they haven't told us that you did the hours.
right, well, that's the reason why he's checking to see.
Okay, November the 14th will be the next hearing.
Okay.
Is that, you are available then?
Yes, Your Honor.
Okay, November 14th. Get it done.
State of Ohio versus Beth Igo, case number CRB 25644.
This is an arraignment.
Yes.
You bet I go.
And you're going to be representing her, Mr. Morford?
I am, Judge.
Do you wish me to read these charges into the record?
I would waive reading, Your Honor. Ask you to set an OR bond. She's appeared here voluntarily.
She has a bond up.
Oh, she did? But
She's supposed to bond
okay.
Mr. Sellers. According to,
We'd ask you to continue that case.
I will continue it. And there are not guilty plea. When do you want to come back for pretrial?
You want to do it the 27th, Judge,
That's fine.
of October?
October 27th, do pretrial at 10 o'clock.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Larry McNamara, case number CRA 25647.
Ma'am, who are you?
I'm Kayla. I'm staff at the treatment facility he's at.
Oh, okay. What facility is that?
Serenity Springs,
Thank you.
Where's that located?
Ashland.
Should be in my file.
There's nothing in the file on that. All right, this is your arraignment. You are Larry B., is it?
McNamer?
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 McNamer. All right, Mr. McNamer, you have a possession of cocaine charge. That's a felony of the 5th degree. Were you here when I explained defendant's rights?
Yeah. I
Do you
know.
understand your rights?
Yeah.
Possession of cocaine is felony 5, maximum penalty is a year in jail, $2,500 fine. The state's alleging that at Union Township, October the 8th, you knowingly obtained, possessed, or used cocaine. Do you understand the charge?
Yeah.
And you've got a South Point address?
Yeah.
Was he in your facility?
Not at the time.
Okay. So just recently you went there, since this happened? All right, you understand the charge, sir?
Yes, sir.
You have the money to hire a lawyer?
No, sir.
You have a job?
Did.
What'd you do?
Case manager at a treatment facility.
Which one?
Restoring Hope.
Okay. Mr. Morford, I'll appoint you. McNamer is his name, Larry McNamer. What's the state's position on bond?
Your Honor, Mr. McNamer posted a $2,500 cash bond, it just has not been received yet.
Okay, he's posted a bond, so that is noted on the front of the file. So, okay, that's continued. Any other conditions of bond?
We would want him to stay in his treatment. We're glad he's already in treatment.
Well, my only problem with that is I don't know anything about the facility. I don't think I've ever worked with your facility.
We've been open since November.
Okay. Do you have the Medicaid card?
Yeah.
All right, well, I'm going to require that you go to a facility that the court works with. He's inpatient with you or outpatient?
Inpatient.
All right, I'm going to, do you have any problem going to a faith-based facility?
Yeah, I'd prefer not to.
Okay. I'll refer you to talk to him and figure out where he's going to go. All right, so go talk to some folks that are here that are going to assess you, and then you come back and we'll finalize things. So I'll recall it. Do not.
All right. Thank you, Your Honor. Yeah, want to figure this out.
Go get the second, we'll go back.
All right.
State of Ohio recalls Kyle Maynard, back in Colby, case number CRB 24478.
Your Honor, I'm spoken to Fifth Department PCC.
Yeah.
He's going to go back and he's doing the tape.
Okay. That's a much better decision. You have to commit to doing this, Kai, and you can do it. It's not like, there's some people, well, very few, but there are some, I feel like they're so far gone, they're not ever going to do it. You're not in that situation. There's so much at stake here. You just have to put your mind to it. I know it's difficult with the circumstances you're in because of your wife. But you got, she may be out of the picture now because she has a trafficking charge. What? How? How's it changed? Is there a case going away?
I think you talk about it.
Well, that's what I'm saying. She may be out of the picture or not I think she was a bad influence on you, and she's not gonna be there with the child. So you're gonna have to pick up the cudgel and go forward, take care of this child down the road, and be a father that's clean. Okay, that's the goal. I hope today is the last day you ever wear an orange jumpsuit. That's my goal. I get no pleasure seeing you in jail. In fact, it hurts me to see you in jail because I know your family. I know your mother. And I know this is terrible for her. But my main focus is your baby girl, right? It's a girl. If we do things right, she's going to be alive in the next century. And what you're doing right now this is the most important years of her life. She needs you more now than ever. You're laying the groundwork for how her life is going to be. And what you're laying right now is not good. She may overcome it. There's a possibility she could overcome it. But we know statistically, if you got a parent that's using, the chances that you're going to use go way up dramatically. Plus a whole bunch of other bad consequences from that. Have you ever heard of ACEs, adverse childhood experiences? You can add those up and then look at if you look at what people's adverse childhood experiences are, then look at them when they're 25, you're going to see those results. One of the ACEs is having a parent that uses. That's an adverse childhood experience. Having a parent that goes to jail. That's an ACE. That's an adverse childhood experience. Having a parent that's not in the home. That's an adverse childhood experience. The more of those you have, the more likely you're going to have a lot of trouble in your life. And you don't want that. You love this child, right? You want the best for her. You show me that and show her that. Okay, I'm going to order that you go back to the counseling center with a GPS monitor. You cannot leave without permission of the court or permission of the counseling center. If you cut the ankle monitor off, you are going to go to prison. Is that as clear as it can be? And I'm hoping for your success. I want you to be successful. Okay, let's what's your non-availability?
They have the OR down.
2,000 OR.
You taking this one, Ron?
He knows what he needs to do. He's been there, and the truth is, when he's there and people are telling him what to do, he does pretty good. It's when he gets out and has to make his own decisions, bad. I'm thinking more like 1st of November. How about the 3rd?
I'm not able to third.
Well, okay, that's no. 14th, November 14th. Okay, next hearing, November 14th, for a pretrial. 2,000 OR, counseling center with GPS. And I don't know when the GPS is going to go on, because it's hard to get on Fridays.
State of Ohio versus Presley Board, case number TRC 25-1946, A and B.
This is Mr. Beach's case, and it's set for pretrial.
It is, Your Honor. I believe Mr. Cremines, Judge Cremines excused his appearance at the last hearing. I know we agreed to that. I'm okay, Your Honor, doing one of two things. My suppression motion's pending. I don't mind to come back and pretrial the case, with Mr. Heald again, or I don't mind going to the motion here. I'll defer to him. I have no, the only thing I ask, Your Honor, is my client's out of town working. I'd ask it be set December 1, 5, or 8 at the court's convenience.
I have an entry on limited driving privileges. Has that already been entered, or I haven't signed it, and Mr. Heald has not either.
I'm guessing no, Your Honor. I don't believe we addressed that with Judge Cremines.
I don't remember, but if
It
there's
is
no entry, I
first
guess we
offense.
didn't.
I would request that if it's not been entered, Your Honor.
We're okay.
Sign it, Mr. Okay, I'll just approved in court. And I'll execute that. It's in the file if you want to get copies.
Yes, sir.
What's your preference? You want a pretrial probably?
Yes, and I've looked over the materials a little bit, and I've tried to study through Mr. Each's voluminous motion to make sure that I understand every bit of it. And so there are maybe some issues that we'd be willing to discuss.
There's also some videos that we're working through, Your Honor. This is the trooper that made the stop, didn't conduct the field sobriety test, but we won't have any trouble sorting those issues out.
Have you gotten that video from the first trooper?
Yes, sir.
Okay. So we're okay with the pretrial on that.
I think that makes sense, Your Honor.
What dates are, and I'm not really saying anything now till the 27th or after of October. What's your preference, Mr. Williams?
December.
He told me some dates he was available.
Yes, sir. Monday, December 1, Friday, December 5, or Monday, December 8.
The first is good.
Yes, sir.
There's a time waiver to him.
I have my suppression motion, Your Honor, but that's certainly,
Okay.
it's
December
filed.
1st for pretrial on motion. 10 o'clock.
Thank you.
State of Ohio versus David A. Campbell, case number CRB 25378. Mr. Morford's case.
This is set for pretrial today. It's Mr. Morford's case. David Campbell. He's at the VA, I think. I did get a text from Amanda Rayburn, but I'm not sure it was on this case. I'm gonna check. Okay. That was Russell Ferguson. Any word, Mr. Morford, on where Mr. Campbell is?
I can't help you, Judge.
Okay. Will be a warrant for failure to appear. And I'll let her know that he didn't appear today. So she's
Okay. Thank you, Your Honor.
You're welcome. Oh, okay.
State of Ohio versus Charles Fricky, case number CRC 241281, A and B.
Hey, John.
Yeah, he's been in He's already left.
Yes.
He's suspended.
See you guys.
I give you the letter. That's the one passed on to me.
Oh, okay.
Okay. Congratulations on getting your job.
Thank you.
Good report. So this has been on a probation violation. I think he's demonstrated enough at this point that we can go back to just put them, I'm not going to give him any additional penalty. He's done well. Unless there's an objection to it, I would just put him back on the review docket. He still has fines and costs to pay. He's done his community service.
You have taught me when to be quiet, Judge.
Okay. No objection from the state, I'm assuming.
No, Your Honor.
All right, no penalty on probation violation. I'll dismiss it because he's done well since then. And just put him on the review docket. And with your new job, Mr. Fricky, what's best for you to come in on Mondays or Fridays? Matter?
Mondays.
Mondays are better?
Yeah.
November the 10th. 9 o'clock.
I do.
State of Ohio versus Ryan Slayton, case number CRB 25588.
Mr. Morford's case, that's a pre-trial. Well, actually, it wasn't. He had missed previously. It's Mr. Morford's case. It was set for a pre-trial October the 6th. My notes where he wasn't here that day.
I was gonna say, do I need to go get that?
No, it's okay. I'm sorry, I got my dates mixed up. I apologize.
He got his dates mixed up, Your Honor. It wasn't an intentional act.
Okay, well, he's here today. It's a disorderly M4. How do you want to proceed?
10 days suspended.
You're 10 days suspended. I'll take that. Here, what's that? 10 days in jail suspended. If you don't get any probation, I think we're going to have a change of plea, Your Honor.
Okay. What pleas you wish to enter?
Guilty.
Is that correct, sir?
Yes, sir.
What's the state recommending?
The state is, and I will say, Your Honor, I don't have his file out here. I don't think there's anything real unusual. I mean, everything's unusual, I guess, but we would just ask for 10 days in jail suspended.
Okay.
Unless there's something
I don't see
that
anything.
indicates some big problem.
Seeing anything in the file that would jump out and he's warranting something different. You have a right to make a statement, Mr. Slayton, if you want to. Do you have anything you want to say before I send it to you?
No, Your Honor.
Okay, I'll send you. Costs. 2 years of level 5 probation, which will end once you take care of your fine court costs. I'll set a review hearing for you April the 17th. So you got 6 months or more to pay this. If you don't pay it, you got to show up for a hearing. If you don't show up, that's the only way you can go to jail. Blow this off, miss your review hearing, you'll get a warrant then.
Yes,
Pay
Your
it, and you'll never see the jail.
Yes, Your Honor.
Go check in with Mr. Major. He's your probation officer. His office to the left. As you exit the courtroom, go to the left. That counter is the probation. Talk to him. He's going to give you some paperwork. You're free to go after that.
Yes, sir. Thank you.
Any questions?
No, sir. Thank you.
You're welcome.
Thank you, Judge.
You're welcome.
Thank you, Mr. Wolf. Thank you, Mr. Wolf.
You're most welcome. Take care.
God bless you.
God bless you, sir.
State of Ohio versus Jonathan Worth, case number TRC 251662, A and B.
All right, this is set for pre-trial today. And Mr. Ward, do you have an attorney today?
No, sir.
Are you still seeking to hire an attorney?
No, due to personal reasons, I chose not to go with one.
Okay. How do you want to, are you going to represent yourself? How do you want to proceed?
I'd like to do that, yes, sir.
All right, well, since you're representing yourself, let's see what and I have a note that the urine BAC was 130, is that right?
It was urine alcohol was 136.
Okay, maybe that's the equivalent on the BAC, 136. Well, I said 130. 1.1 is the per se for urine, so these are the per se. So do you just want to trial this, or do you want to hear what the prosecutor is going to recommend if you please?
I'd like to hear that.
Okay, what's the state recommend?
Your Honor, if it please the court, this is a first offense. The score is over the legal limit. It's not extraordinarily high, however. So from that perspective, it's not entirely aggravated. The reason for the stop was a speed 71 and 55. And that was the reason for the stop. There was no other erratic driving. So we would recommend the minimums if he were to plead guilty.
Okay. Mr. Worth, what's your response?
I was curious if it'd be possible to apply and be reviewed for a diversion due to, I'm requesting this because due to some recent changes in plans, I have, after the current project I'm working on is done, I plan on seeking schooling for crane operation and going into nuclear facilities. And I don't think this would destroy that chance, but like having this on my record, but it might impede it a little bit, being an operator in a nuclear facility. And I was kind of hoping I could go for a diversion.
We don't have a diversion program for an ODI, so.
Okay, well then I'll plead guilty.
And you understand that means you're admitting the charge is true?
Yes, sir.
Anything you want to tell me before I sentence you?
No, sir.
Do you still live in Pomeroy?
Yeah, but I got a place that I stay at while I'm working over in Huntington. I'm working at the new core facility.
It's still a little bit of a drive for you.
It's not nearly as bad. And then the direction of traffic with all the people, it crowds up pretty bad coming from the Gallipolis end, so it's a little bit better on.
You're doing the construction, working on construction there?
Yes, sir.
Yeah, it's a huge operation there.
Yeah.
It's like.
That's
Okay, I'll give you, the state's recommending the minimum penalty, so the minimum fine is $375. That's what I'll impose as your fine. Order that you pay the court costs. You get a 6-month license suspension that started on July the 5th. So it's going to go through 1/1/26.
So that's post-dated for when?
Yeah, it started, because it went into effect, well, actually it didn't. I was thinking that it did, but it was a urine screen, so there wasn't an automatic license suspension here. So, sorry about that. It starts now. So you weren't under an automatic license suspension at the time the citation got written.
Your Honor?
Yes, sir.
Would it be possible to acquire privileges for work and like going and picking up my children whenever I have them every other weekend?
Yes, there's actually 2 possibilities now with regard to driving privileges. I can give you unlimited driving privileges, but you have to place the blow-and-go device on your vehicle. If you do that, you can drive anywhere, anytime. You just have to blow in it before you start the vehicle. Now, and there's a fee. You don't pay the court, but you have to have it placed on there, and there's a fee for doing that and for keeping it. If you don't want to do that, I can give you limited driving privileges, and I will give you privileges to drive for work, to and from work, and part of work. Child care, I'll give you privileges to drive for child care. Is there any other emergent type driving you would need? You're gonna have community service, I'll give you privileges to come to community service and drive to that. I think that what's,
Driver's intervention program.
yeah, you'll have to go to a DIP school, so I'll give you privileges to driver intervention program to go to that.
Okay, with the blow and go, do I have to change my insurance situation in order to have the?
I don't know about that. That's a good question. I've never had that question come up.
Okay.
You can talk to the probation officer. You don't have to tell me right now if you want to.
Yeah, can I do that?
Yeah, because you're going to talk to him anyway. That's who you would go through if you want to get the device placed on your vehicle. He's the one that will set it up for you to get it done.
Okay.
So talk to him about it, and he can answer your questions. I'm going to require you to do 30 hours of community service. You can do it on your days off. We have a community service program here at the court, 7:30 Monday through Saturday. Sunday's the only day we don't have community service.
It's my only day off.
Well, we can work with you, assuming at some time you may have to take some vacation time or whatever to get it done.
I just acquired vacation, so I'll work it out.
Okay. You have to go to the driver intervention program. That's a 3-day program. That's required. You can go to anyone that's approved by the state of Ohio. There's one here in Lawrence County. You don't have to go to it. You can go to others. There's others that are cheaper. So if you want to go to one that's out of the area, that's fine as long as it's approved by the state. You can go there.
Okay.
Get it filed with the court. Your review hearing is going to be April the 17th of next year, so you got a long time to get this stuff done. You get it done, everything, you don't have to come to that hearing. The hearing is to make sure you do what your orders do. So just kind of, confirm with your probation officer you've done everything, and then you don't have to come to the hearing. If you don't have it done, you got to come to the hearing. If you don't have everything done, you don't come to the hearing, you're going to get a warrant for your arrest.
Okay.
On the speed offense, I'll propose a $50 fine. Any questions?
No, sir.
Go meet with Mr. Major. His office is to the left as you exit the courtroom.
All right. Thank you.
You're welcome.
State of Ohio versus William Keplinger, case number CRA 24631, and CRB 211152.
Mr. Sires, representing Mr. Keplinger, I have a report in my hand from RRS. Compliant. Screens are good. So it's a good report.
I'm also working, Your Honor.
I'm sorry?
I'm also working too.
Oh, good.
Hey, Mr. Kaplinger wanted to inquire about going home at this point. He is inpatient right now. He'd like to return home.
And he's with Flux Group and
It's hard for them to get me back for work because I'm out of their range, so I have to arrange rides myself.
Well, we need Jeremy from RRS. And you started residential July 19th?
Yeah.
He's requesting outpatient.
That's just like the other one, I have to talk to this treatment team.
Okay, let's do that. Let's come back pretty quickly, let them look at things and make a recommendation on that issue.
When would you like to give me back, Your Honor? I'm available.
Got 10 days. We'll come back on October 20th. And you can have them do a report addressing that issue.
Yes, sir.
At 10 a.m.?
Yes.
Yes, sir.
All right, thank you.
Thank you.
State of Ohio versus Charles Cochran Jr., case number CRB 25625, CRA 25517.
Stars case. On their hearing and pre-trial, and it looks like there was some kind of probation issue.
It's not probation, Your Honor, just a bond issue that arose. I don't think it's taken care of at the moment.
He's had good screens, and from the report, it looks like there's been a lot of progress made on his attitude, I think.
Yeah, we are here, Your Honor. I guess last week there was an issue where Mr. Cochran had left another treatment provider to go to, I'm going to say a third, although that's because this is the second one. Went to a second one voluntarily, but there were some issues with maybe that wasn't the best fit from the court's perspective, so Judge Kermeans ordered him instead into hometown where he is now, and he's doing well there.
Okay. Come back in a month, roughly?
It sounds agreeable, Your Honor. 7th or 14th work, the 10th I'm in trial.
Let's do the 14th.
I'm sorry, no, the 14th doesn't work either, I apologize. The 7th or the 21st or the 17th.
Work or don't work?
They all work, I apologize. It's getting confusing.
7th, what was one in, was there one in between that?
The 7th, the 10th or the 14th, I have trials on both days. That week, I've got trials beginning and end of the week. 17th, I'm available.
17th.
17th, then, thank you.
November 17th, 10 o'clock.
Thank you.
And there is an assault involved in this too, so we're going to want to address that the next time.
Yeah, I need to file discovery on that.
November 17th.
State of Ohio versus Matthew Paul Starcher, case number CRA 25434, CRB 25435.
Stars case, preliminary hearing and pre-trial. He's at focus. So see, we're getting ready for going to outpatient and employment services for working.
Yeah, the treatment team feels it'll be beneficial if his GPS restrictions are modified to allow him to obtain employment.
Okay. Does he have a monitor on?
He does.
So you're agreeable with it being removed?
Yes.
Okay. So is there any objection from the state?
Well, we're glad he's making progress, so, you know, with the idea in mind that how we got here is a pending second-degree felony, so hopefully his behavior is such that there's confidence that there's not going to be a problem.
Okay, so I'll order it removed, GPS ordered removed. You'll see Mr. Major in probation to facilitate that getting down.
You have your charger with you. They don't have to have your charger to get it actually removed.
Would they be able to remove it at the common police courthouse?
You have to talk to the major about that, but I can tell you he's gonna have to have his charger before they remove it.
Okay.
And do the 17th.
17th, yes, I can do that, Your Honor.
November 17th will be the next hearing. Okay, good job, Mr. Stoney.
Thank you, sir.
State of Ohio versus Kelly Doss, case number CRA 25206, CRB 25207, A and B.
Mr. Doss, has it been to Rodriguez?
Yes, sir.
Cyrus is attorney.
Okay. So I'm understanding there's a non-compliance noted here, but he has become compliant and remained compliant since this has been written.
Okay. Well, that's good. Does he have he has a GPS, right?
No, Your Honor. You took it off.
Already off, okay.
Yes, sir.
And you didn't leave?
No.
Okay.
I've stayed and I've done it because you gave me the chance, Your Honor. I'm trying to do it for myself this time.
Ultimately, it affects all of us, but it affects you and your family the most.
Exactly. The only reason my family's not here, she had a doctor's appointment this morning, so we got us a place now, so when I do get released, we was able to get us a place to live and rent it, and I'm just waiting to complete my program.
Okay. Looks like you got things going the right way.
Yeah, thanks to you.
Thanks for taking the opportunity to get clean.
Thank you for giving me the chance.
Want to do the 17th on this one also?
I think that sounds reasonable, Your Honor.
Okay, keep it up.
Write that down. Good job.
Thank you.
State of Ohio versus Mike Ferris, case number CRB 25247, example sentencing, Your Honor.
I'm not going to where I got more case.
All right.
Mr. Morpher's case, sentencing. Fine has been paid.
Yes, sir, and I work 6 days a week, and I didn't have a car. I've got me a car, and I'll be able to get my community service completely finished real soon.
Okay.
And we'll do community pickup days tomorrow from 8.
Tomorrow you get 2 days credit.
It goes from 8 in the morning till 2 o'clock or 3 o'clock in the evening, and I'm doing that.
Okay, mid-November, Mr.
14?
Okay, November 14th will be the next hearing. For sentencing. Okay.
Thank you, sir.
You're welcome.
See you then.
And thank you.
Yes,
State
sir.
of Ohio versus Angela Spurlock, case number CRB 18-1327, CRB 18-1297, CRB 18-558.
I've been doing community
More
service.
for this case, sentencing.
And I might have a job there. Dog pound, anything. You got contact information for them? Different people sign it. It's at the animal shelter, Cavalry and shelter.
Your Honor, I would have to get this confirmation on this community service. There's no contact information. She said she done it at Huntington Animal
Cavalry.
Shelter.
Yeah.
Okay.
But there's no, I have nothing on it. There's 2 different signatures. And
Yeah, you can call them. But I might have a job there though, because they like to handle the dogs, because I'm really good with animals. So I put in an application and the director talked to me the other day, so.
All right, Mr. Cooper, we'll look into it.
It's legit.
November 21st.
Yes, Judge. Wait a minute.
Okay, that's all.
Thank you, Judge.
Thank you, Your Honor.
You're welcome.
Have a good weekend, guys.
State of Ohio versus Terry Stover, case number CRB 2559.
Taylor Stovers with Bethesda.
Madam President.
Yes. Thank you.
That's Terry Stover. Let's go over there.
Okay, this is one we discussed before.
Yes, so I spoke, the nurse called me just a little bit ago to let me know that she's requested documentation that she still hasn't received. That you're going to an online pharmacy or an online doctor, from my understanding.
Well, that was the first initial one I had because I'm not allowed to do 2 different treatments.
Right.
So I'm not allowed to do the treatment with them. I have to do treatment with you guys and I just get my medication. And that's what I was trying to do and trying to figure out because as soon as I'm done with you guys' treatment, they want me to start treatment with them. I can't do 2 at once.
I'm aware. So
Yes.
my concern is that we didn't write those prescriptions because we don't approve of the combination. It's deadly, actually.
Right, but the nurse said to get the statement from the doctor that I've already signed.
That you would sign a waiver.
Yeah.
I don't think the court would be.
Okay, I'm going to require you to do the treatment through Bethesda. No outside, no online doctors.
All right.
You have to do what they set up for you. And I'm going to give you another chance to do it because I know you've got a child. If you're non-compliant, the next option is either go to jail or go inpatient. So let's get it in line. I want to see you on the 20th, 10 days.
Okay.
Your Honor, I have a question.
Go ahead.
Oh, she pled guilty, okay.
Yeah,
I was wondering why she didn't have a lawyer.
She does have a lawyer.
One of the things that I wanted to make sure that we don't lose track of is that this happened at Speedway, but she was an employee there. And they say that she took $537 from that.
Restitution.
So that's going to be needed. She may want to start thinking about that even if the court hasn't ordered it yet.
Yes, sir. I work full-time. May I say something? I'm sorry. I just started my school back up, so I have to finish my associates online at night. But I do work full-time, but they're having me do I have to be there 6, groups every week. So I'm not able to pick up other hours, but I would like to, I didn't know that was going to be a problem with, the doctors and all this. I thought everything, when I spoke with Jess, I thought that's what she told me. My most important thing was to get that road out. Where I just came to Ohio, I just got the Ohio Medicaid. So I do apologize. I am sorry. I don't want any problems. I don't want to be compliant in everything that I do. That's why I wanted to plead guilty, and I was hoping to conclude everything today. But I was hoping to get maybe on probation so I could get like the community service and start paying the restitution and try, because she said once I got my prescription, I could get the hours knocked down, because I'm going 6 days a week to this place.
I don't think that is correct at all.
Yeah, I do feel good.
I promise you, I'm the director of operations there, and that is not correct.
Okay, let's come back in 10 days, ma'am, and
Can I get proof of that?
I don't, you go through Bethesda for your medications, you don't go through an online doctor. Come back in 10 days, let's see that you're compliant. October 20th.
Thank you, Your Honor.
State of Ohio recalls Adam Searles, case number CRB 25-646 AMD, and Courtney Searles, case number CRB 25-645.
All right, Mr. Steyer represents Courtney Searles, and it's my understanding Mr. McCown is going to represent Adam Searles. We took a break to see if we could.
I wasn't able to reach Mr. McCown to discuss a couple things. So at this point, I think it would be best if we do in fact have mutual protection orders. There's already a protection order in Mr. Searles' favor out of the Common Pleas Court, and I'm always less comfortable having that going only in one direction. So I think it's better to go ahead and have both. I was hoping to raise these issues with Mr. McCown. I was unable to reach him. Ms. Searles would like to get her medication, some clothing, and her government documents from the home. They're in the marital home. He's living there, and he has a protective order that bars her from the home, so she's unable to get her property. So she's named a third party. What was the name again? An individual named Cresta that she believes would be willing to go over and pick up those belongings, and he just nodded his head, so it sounds like he's probably willing to let her do that. And I just would like to, I don't think there'd be an issue with that, but I'd just put that on the record that we're doing that, so that if there's a problem raised about it later on, we can say we've addressed it. The other thing in the immediate future we need to address, and some of this can be addressed down the road through this and or what goes on in the divorce, is their daughter this weekend has a cheer competition. She'd like to be able to attend that. She doesn't object to his attending it as well. It's in a place that's big enough that they should both be able to be there without having to interact with each other. So again, I told her I would raise that issue here before the court. He's nodding his head, so it sounds like we may be able to handle that peaceably as well.
All right, Mr. Searles, are you agreeable to the person she's named to come over and pick up some of her personal items?
Yes, Cresta Ferguson can come up there and get her personal items with like a 1 or 2 day notice. I agree with that.
Well, you're getting a notice now. When can she be there? Tomorrow? Does she live locally?
Yes, she lives right across from him.
Oh, okay.
So
well, it shouldn't be a problem.
Yeah. We have to set a time frame, like for you to know?
I don't mind.
No, just you guys figure it out. There's too many people's schedules involved.
I talked to Cresta. She was up there yesterday, so it's a mutual.
You're okay with her contacting you, this Cresta person?
Yes, she's talked to me yesterday, yeah.
All right, and then the other thing is this cheer competition. You're both agreeable that you can both be in this gymnasium at the same time?
Yes.
Now, I have been told this, and maybe I'm getting wrong information, that one or both of you are calling the sheriff's office continuously. Now, I don't want anybody to get hurt, so if that's so it's a fine line. I don't want anybody to get hurt, but we need to calm this down and start acting like adults and leave as much as possible police agencies out of it, okay? All right, everybody's shaking their heads, so I assume that's agreeable. It seems like we probably need to come back pretty quickly on this, so
That would be my thought.
maybe
Now,
next Friday.
we're complicated by Mr.
He can appear by teleconference. I don't know.
Okay.
Is he in Germany? Where is he?
I don't know where he is, I just know he's not here today.
Well, his father passed away.
I understand that.
But-
That was some, when they were coming here.
I don't think that's what the issue today is necessarily, I'm just saying I don't know what his schedule is, but I'm here next Friday, so I think,
Put it on the.
put it on the docket, if there's a problem arises, Mr. McCown knows how to get a hold of me and knows how to get a hold of the court.
Mr. Sherrills, if you would ask, and he knows Mr. Steyer very well, to reach out and get a hold of Mr. Steyer and discuss some of these issues.
So it's,
That'll assist getting some of this done. October 17th is going to be the next hearing at 10 o'clock.
Yes.
and what, the next hearing, what exactly?
Don't leave
It's a pre-trial.
until
The pretrial?
Yes, sir.
she's gonna come bring it to you. But the judge has to sign it.
Okay, where was
So
it?
just stick around, I'll come by in a minute anyway. Thank you, Your Honor.
You are.
This place.
State of Ohio recalls Larry McNamer, case number CRA 25647.
You got something worked out?
We can take them, RRSU.
Okay. And that's today?
That's the day.
Okay. All right, he's going to RRS as part of his bond.
So, is that releasing my bond?
No, your bond's staying in effect.
Still staying in
As a condition of bond, I'm saying you gotta go to treatment.
All right.
Mr. Morford's gonna be the lawyer. How about coming back on the 20th? October 20th?
That's good here, Judge.
20th of October. On their hearing. Okay, come out with a good report.
Thank you. Thank you, Your Honor.
Hey, Butch. State of Ohio recalls Christopher Conwell Jr., case number CRB 25597, CRB 25548.
Correct, case.
We've had,
They scheduled an in-person appointment for 29.
yeah. Well, they say you're compliant. I just don't have a report from that.
She hasn't been there in person to sign a release of information form, is what I was told this morning, why they haven't. He's just done it for like a telehealth thing.
Okay. Well, next time we're going to need a letter from Pat, so make sure we have that. But he's compliant with PATH, what I've, what's her name from Bethesda?
Taylor?
Yeah, Taylor. I'm drawing a blank. Taylor contacted PATH, and PATH indicated that he was compliant.
Okay, Mr. Gilby.
We're satisfied for the moment. We want him to continue with that, and we will have to address the underlying reasons why we're here at some point. But for now, we're okay. Yeah.
November 3rd,
The next date,
7th?
yes,
All right, November 7th.
November 7th. Just make sure we do have a letter from Pat. Okay, all right, you're good.
State of Ohio recalls Dustin Hines, case number TRD 25-1837.
Okay, this is set for pre-trial today.
Yeah, Mr. Hines was just a little late. He's coming from the
Elkview area.
Yeah. So maybe we can resolve this matter today. That way he doesn't have to travel back. So
What's proposed then?
the state,
Okay, this is a driving under suspension.
Yes.
Your Honor, we'll just, if we plead the charge, just ask for a fine and cost if possible.
Did he get reinstated or?
No, I got about $350 left to pay in West Virginia for my West Virginia license is reinstated. But I recently moved, and like in the move, I found a paper, like I don't know if I'm like incriminating myself or not, but like Colgrove was saying that I was out on bond and owing them $1,260 before this incident. So like, I mean, it was basically saying I had a warrant out for me for failure to appear, but the cop that pulled me over up here, up the road for this incident, never said 2 words about a warrant or taking me to jail or anything. So I don't know what's going on over in Colgrove, but I do know that they want $1,260 from me for something. Like I've been trying to contact them, like I'm off work now until Thanksgiving, but so I have like some time to take care of that stuff over in Colgrove, but I have no idea what it's even for really. I did a job over there 2 summers ago and got pulled over there one time, but I thought I cleared all that up.
I think he wants to clear up this matter today, Your Honor, at least this one.
Yeah, I'm willing to just take it and whatever I need to pay and stuff, like, you know, I probably can't pay it all today, but set me up on a payment plan, whatever.
Well, the officer did not, which is unusual, he did not attach a copy of your driving record. So I don't know what the basis of the suspension is. I mean, if you plead guilty, you're admitting that you were suspended. If you want proof, we can make the state get proof. They have to show the reason for the suspension. I don't have it in the file. I don't know if Mr. Heald has that information.
I don't, Your Honor.
The court accept a dismissal with court costs?
Well, that's up to the state, what they want to do.
Well, we'd have to get a copy of the driving record and probably would need to come back on another day. Right now, I don't have anything.
You just want me to be done with it?
Yeah, the only thing I have is a statement of the officer saying vehicle tag lights were out, tags were expired, contact the driver, and he was suspended. That's all it says. Usually, they will attach a driving record, and there's one attached.
To the suspension.
That ball's in the state's court.
Well, we'll get a driving record and come back on another day, I guess.
Okay.
All right.
Now, if I get my West Virginia license reinstated and I come back and it's reinstated, will this be dismissed?
No, but that certainly would help. That doesn't mean you weren't suspended at the time you got the citation, but that's mitigation. Big fancy word to mean you took care of it. And that helps.
So maybe.
So you say you're living in Elkview?
Yeah.
That's on the other side of Charleston, right?
Yep.
Okay.
I had an opportunity to buy the family farm back, so that's what we did.
So maybe November 17th, around that area?
That's fine. At defendant's request, the case is set for November 17th for pre-trial.
Get your license taken care of if you can. All right, find out about that Colgrove stuff.
I will. Here we go.
State of Ohio recalls Michael Howard, case number TRC 25356, A and B.
Okay, this is for a review. This call this morning is a review. And Mr. Howard, you owe some, looks like court costs, I guess. Are you,
Yes,
can you pay something on that today?
yeah.
How much?
I don't know how much I got with me. Probably 100.
Okay, I'll put you down for that. Go see the clerk. Once you paid it off, you can quit coming to these hearings.
Okay.
I'll set your next one for November 21st.
Okay.
Get it paid before then, you don't have to show up. November 21st, 9 o'clock.
State of Ohio recalls David Campbell, case number CRB 25378.
Okay, Mr. Campbell's here. Okay, it says he's completed the program at the VA called Strength at Home. That's the name of the program.
Well, I haven't finished yet, Your Honor. It'll be finished Monday.
Oh, okay, it says.
Yes, the 13th.
Well,
It's close enough.
it says Mr. Campbell has successfully completed the program. So.
Okay. That works, Your Honor. Okay.
What's the state want to do? To domestic. Anyone is domestic.
May we approach, Your Honor?
Yes.
Yeah.
What's your schedule in November?
You looking at mid-November, Your Honor?
Toward the end. 24th?
I have a trial then, Judge.
21st?
I'm here.
November 21st?
Yes.
For a pre-trial.
Just to make sure you're good. Thank you, Your Honor.
You're welcome.
State of Ohio recalls Robin Ball, case number CRB 25636.
Your Honor, I just sent her to the clerk's office.
CRB 25637.
Ma'am, you're up.
Okay, this is set for arraignment.
Hello.
You're Robin Sue Ball.
Yes, sir.
Has she been served a copy? Here's some. You know them all?
Yeah.
Ma'am, you just been handed a copy of the charge that alleges on October the 7th, in Fayette Township, you purposely tried to defraud Walmart property without their consent. First degree misdemeanor theft offense, maximum penalty 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, sir.
You understand the rights you have as a defendant?
Yeah.
How do you plead to this charge?
Well, I'd like to get a lawyer
Okay, I'll enter a not guilty plea for you.
until I can see what's going on.
Do you have a job? How do you?
No, not right now.
Yeah, no
I'm
income?
unemployed.
Morford, John?
I'll appoint Mr. Morford,
Okay.
enter a not guilty plea for you. Yes, there's 637 too. I missed it. Okay, she has another charge we need to service.
Hello.
How you doing?
All right.
636.
Okay, thank you.
There's a 636 too. Here's server also. They only gave you one copy.
You need a copy of this?
I'll need a copy of it.
You want to look at it real quick and I'll
Yeah.
make a copy?
Sure, what is this?
It's a theft by deception.
Okay.
That's what you got here.
Okay.
Your Honor, Mr. Morford said I already gave it.
Okay, it's 637, but 630, there are two different charges.
Both the same victim, Judge.
Yeah, but they're different dates. No, different victims, South Point Food Fair in 636, Walmart in 637. So 636 alleges that if Fayette Township on September 11th through 20th of this year, she purposely tried to defraud South Point Food Fair property with a total value of $334.72 by deception. So that's the first degree misdemeanor also. I don't think she has a copy of that charge.
No.
Okay. All right, Mr. Cooper's going to make you a copy of that charge. I'll enter a not guilty plea on both charges. Setting pre-trials for 27th or after of October.
I want to do 27th. It's going to be a killer day, though.
They're all killer days now.
That's true.
Yeah, 29 pre-trials today. All these are in the 20s. October 27th will be the next hearing, 10 o'clock.
I will. Okay, thank you. Okay.
Thank you. Give me a call.
Okay, thank you.
Thank you, Judge.
Yeah, she needs a signature bond too, so.
Ma'am.
You can make it 1,500.
What is this?
This is just your bond. You're signing a promise to pay the court $1,500 if you don't appear when you're supposed to.
Will she need fingerprinted?
She will need fingerprint too.
Just wait on me up in the lobby, I'll bring you a copy.
Okay.
Thank you, Your Honor.
State of Ohio, Justin Marshall, case number TRC 2571.
Okay, this is set for a motion hearing today. This is the attorney.
That's what I say, I'm on a freeze. I'm not. That's what I'm thinking.
Troopers got my file.
Council ready to proceed?
Yes, sir. Yes, sir.
Do you raise your right hand? Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? I do.
Your Honor, I apologize. Would the court cut the volume in the waiting room?
Yes.
Thank you.
Mr. Hill.
Thank you, Your Honor. Deputy, could you state your name and where you are employed?
Christopher Frank, Lawrence County Sheriff's Office.
Were you working as a deputy with the Lawrence County Sheriff's Office on April 17, 2025, around midnight, thereabouts? And at that time, did you have occasion to come into contact with Justin Marshall?
Yes.
Do you see Justin Marshall in the courtroom today? And if you do, could you point to him, please?
Right there.
Clerk Shea, point to the defendant.
You were on patrol when you had contact with Mr. Marshall?
Yes.
Where were you at that time when you first came into contact with him?
I was on State Route 7, right there at the old Monty's Pizza.
And that's in Chesapeake? At that time, was Mr. Marshall operating a vehicle?
He was.
And did you try to use English here. Did you conduct a traffic stop at that time?
Yes.
Would you explain to the court what happened, what you observed that led you to stop Mr. Marshall's vehicle?
I was right there on State Route 7 at the old Monty's Pizza whenever I observed a vehicle making an abrupt right turn on the 2nd Street there in Chesapeake and had no turn signal and had no tag light, so I pull out, begin to follow the vehicle. In the process, the vehicle almost sideswipes a dark colored sedan parked on the side of the road on 2nd Street. I continue to follow the vehicle under the viaduct of the 6th Street Bridge, come to a stop sign, continue on, the vehicle turns onto 2nd Avenue in Chesapeake, comes to another stop sign, uses the turn signal, turns right onto 3rd Street, comes to the stop sign, turns on the 3rd Avenue, and as they turn on the 3rd Avenue, I conduct my overhead lights to perform my traffic stop. At first, thought the vehicle was going to proceed on to the 6th Street Bridge, but pulls into the CVS parking lot there in Chesapeake on 3rd Avenue.
So when you first saw him, this is that bend in the road as you're leaving Chesapeake, heading up towards Proctorville, right?
Correct.
And was he heading in the direction like he was
Like he was headed towards Proctorville, yes.
And when he saw you, what did he do?
I say I don't know if he saw me or not.
I'm sorry, when you first saw him?
When I first saw him, he proceeded to go around the curve at the beginning of the curve and then made an abrupt right. Then turned on to 2nd Avenue.
So at that point, he's heading back downriver, is that right?
Correct.
And then from there, you followed him and you all ended up in the CVS parking lot, is that right? And that CVS is right next to the 6th Street Bridge.
Yes.
At that time, did it appear as if that was an intentional path that he was taking to get somewhere?
Objection, Your Honor. It's speculation.
Sustained.
Did he do like a big circle?
Not square.
And this was at midnight?
Yes.
And was CVS open at that time?
No.
Were you wearing a body camera that night?
I was.
And was it operating properly and did it record video?
Yes.
And you turned it over to us for use in this case today?
Yes.
And have you reviewed that since the time that this happened?
Yes.
So after you had Mr. Marshall stopped, did you approach his vehicle?
Yes.
You make face-to-face contact with him?
Yes.
And was there anything that you observed at that time which might have given you the impression that he might be impaired?
There was an open case of Bud Light 16-ounce aluminum cans behind the driver's seat and the back driver floorboard. And he also had glassy eyes almost like he was under the influence, and they were almost bloodshot.
When you were speaking with him, was there anything about his demeanor that might have led you to a suspicion of him being impaired?
Prior to me asking at the stoplight, I told him why I stopped him for his tag light being out. And when I asked for a driver's license, registration, proof of insurance, he advised me that he only had insurance, that he has insurance, and proceeded to get on his cell phone and look for his insurance, and then paused a minute, and then I asked for his identification, and then that's when the chest unit that was out arrived with me, and then I asked for his name and date of birth, and he kind of gave me a blank stare, and then I told him to exit the vehicle.
Did you get the impression, did he appear to not be hearing you or not responding?
He just wasn't responding. I don't know if he, with being under the influence, if he wasn't comprehending, or, but at that point, after telling him for identification and then for his name and date of birth, he agreed to do it, and I had him exit the vehicle.
And I've got video to play, so. Is John here?
Yes.
Did you have him exit the vehicle?
I did.
And
The dragger.
Yes, sir.
Okay.
Just gonna go ahead and get off there. You can do this from your, set down now. It's a wireless mic, wireless one. You can do it from there, up there, either one.
It'll read the time.
Yep.
How you doing, sir? Good. So, your tag light's out. You got your license, registration, proof of insurance? You got your socials? You know, what's your name and date of birth? Sir.
identification? Tony? That's the, you got the signal, left there, turn off the Third Avenue, and I pulled you over for your tag light being out. And you get a complete circle out here. I pulled you out there when I said, how much you guys drink tonight? 2294, go ahead and start that with P this way, possible 419. Would you guys step out the car for me, sir? Let's step out for me. Let's step out for me. Keep your hands seat. Alright. Hey. Go step out the car for me. It's not a request. Your eyes are glassy, and you failed to identify still. So therefore, we're past that. You know, and step out the vehicle for me. I'm going to the court. Go ahead, put your hands on the court, turn around. Put your hands on the court. You got things go publicly, pretty stupid. I'll say, keep your hands up there.
At that point, you searched him. Did you find any contraband or weapons or anything of that nature?
I believe he had, I think, a pocket knife on him.
Now, after this, did you detain Mr. Marshall? Did you put him in handcuffs?
I did.
Did you put him in the back of your cruiser?
I did.
Was he under arrest?
No.
Why did you detain him?
For officer safety, he's a pretty substantial guy because at the time he ended up having his wallet on him. And the other officer stepped away to run his ID with our dispatch.
Is there anything about his demeanor or anything like that that gave you reason to believe that he might cause you a problem?
At first, whenever he was reaching for whatever was in his front pocket, I didn't know if it was a weapon. That's why I told him to keep his hands up there. And I patted him down before I put him in the prior. And also, he kind of tensed up whenever I went to place the handcuffs on him.
Go ahead and put your hands on your back. Put your hands on your tongue. Right now, you're detained. Alright, we'll step back in the vehicle, so we'll post this here.
Did he ask you something there?
He did.
What did he ask?
He said something about his job. This is going to ruin my job.
Yeah, I want to replay this and see if I didn't get through.
Alright, we'll step back here in the vehicle, so we'll post this here. please, that's them whenever they get back here,
He has to use the phone to call somebody to come get him.
please, is it your thing driving? While I'm outside, you will make it there, too?
And did he make another statement there to you that caused you to answer him?
He asked if, between that and dispatch, but he asked if, try again for me.
That's them whenever they get back here, please, is it your thing driving? While I'm outside, you will make it there, too?
All right. You recall what your answer to him was? What you just said there? Did you hear what you just said?
He was asking about the job at the time. He said, "It was a chance for my job."
Okay.
And that's why I said, "No, isn't that what drinking and driving, when that affect that too?"
Did you take that comment by him as a kind of a little bit of an admission?
Yes.
Look at here. How much have you had to drink tonight? Be honest with me. Okay. That was it.
So what did you ask him there?
I said, told him to be honest with me, and asked him how much he had to drink tonight.
What was his answer?
He shrugged his shoulders and said, "I don't know."
Give them a heart. That's it. Everybody finish slide us all over. Go ahead and push right foot in. As he came around the corner, he did signal. I was like, that's right there, that right there. And all of a sudden, he started swaying, and I was clipped the car. I was like, yeah, we go see what's going on. Then he kept all the way around, and just did a big square, and like shot right back behind him. What car did he lose it? He almost, he pulled right out of the underpass, before we get up there. I can't think of what that road is, but there's all the cultural part there, you know, hit dark color, we had showed up for the sedan. So I was like, okay.
So, were you explaining to another officer what you had observed up to that point?
Yes.
And who is that officer?
That is Sergeant Nick Hanshaw with Chesapeake Police Department.
He came on the scene after you'd already made the stop. Now, at this point, going forward, did you find anything, any evidence of consumption of alcohol in Mr. Marshall's car?
We did.
And I'd like for you to explain how that came about, what you saw and when, and what the circumstances were.
Well, when I first initially made contact, going up to make contact with Mr. Marshall, I noticed the open box of Bud Light bottles There were 16-ounce aluminum bottles. It was open, and they were sitting behind the driver's seat in the floorboard. I think there was a blanket, I believe there was a blanket that was also there. Officer Hanshaw goes around to the passenger side, and the floorboard on the passenger side was an open bottle. And I seen there was one beside the case in the back seat that was half empty.
Were you able to see these things without actually entering into the car?
Yes.
So, that open. So, there's. He definitely didn't drink tonight. It's fruits. What out, many? He said.
Those 16-ounce bottles, it's halfway empty, the boxes.
There's one right here. It's half empty.
Got another one right here. Two lids.
Jesus. Let's hold this one. Just want to see the other way.
I was 35. And then when I got up here, I seen that.
That's his phone. I know why. I know why.
I was on the phone with Jeff right now. I even said, first 35 at, he said CPS.
He's not right now. I'll say he's off Tuesday, Wednesday, Thursday, or Wednesday, Thursday, Friday. Yes, we're gonna. He realized he said he wasn't that around to the stop sign right here, and I had to go under the bridge, and he realized that a cop was behind him. He's like, he said, this church thing, I saw some car, yeah, she was it. Although if he came off 70th Street Bridge, he came down this way, or he was somewhere over here, all I noticed that he came around the curve as I was coming off of Bradford, and he just turned abruptly, like in the curve, and I was like, and then he just slowed up that way, and I was like, oh yeah, I'm familiar, and then he turned, and I was like, I said, and your taillights burn out. So it took me a minute to get this part right here, because I didn't see if this was a 1, and then I realized it was West Virginia. So I was like, something happened.
At this point, you're waiting for the trooper to arrive? Yes. You've already called for the trooper to arrive? And while you were they're discussing things with the officer from Chesapeake, did you also confirm that the tail light, the license plate light was out?
Yes.
Now, does this video accurately reflect what you were involved in and what you took part in that night?
Yes.
And I'm going to ask that video be admitted as State's Exhibit 1.
No objection, Your Honor.
We admit it. Do you want, are you going to use it?
Yes, sir.
Okay.
That's all I have for this witness, Your Honor.
Thank you. Deputy Frey, my name is Mike Eaches. If I ask you any questions that you don't hear, doesn't make sense to you, just stop and I'll try to make myself clear. Is that okay?
Yes, sir.
How long have you been employed with the Lawrence County Sheriff's Department?
2.5 years.
You didn't write any report as a result of your involvement in this case, correct?
Correct.
And your cruiser does not have a forward-facing fixed camera like the troopers do, correct?
Correct.
Okay. And have you been through the NHTSA training as it relates to conducting an OVI investigation?
They're in the academy.
So, yes.
Yes.
And when was that approximately?
2022.
Okay. Do you have any medical background?
I do.
Explain that to me.
Worked at Calvin Huntington Hospital for 5 years as a PCA, was a patient care assistant, and I didn't have to, I just pretty much assisted the nurses with the patients when they would come in, whether it be ER or on the floors in the rooms, and I would take their vitals, I would get the blood sugars and things of that nature.
And Mr. Hill asked you, when did you review your body camera footage before you came to court today?
I did.
Did you review it before you came to court on September 5th? When we got started, there was, I think, a technology issue.
I did.
Okay. And I'm sure you met with Mr. Hill to discuss your testimony?
Yes.
Okay. So when you conduct this traffic stop, when you signaled for Mr. Marshall to stop his vehicle, he did so without exhibiting any of NHTSA's clues of impairment, correct?
Correct.
You were trained on the stopping sequence? Yes. Okay. And do you recall your testimony on September 5th, your limited testimony when we got started?
Yes.
Do you recall testifying that Mr. Marshall made a California stop?
Yes.
Okay. And was that true?
Yes.
Okay. And you also do you recall testifying that you told Mr. Marshall the reason for the traffic stop was that he almost struck a vehicle?
Yes.
But the first reason you provided for Mr. Marshall for the traffic stop was his tag light being out, correct?
Correct.
Didn't say anything to him about an improper California stop, correct?
Correct.
Didn't say anything to him about almost striking a vehicle.
Correct.
A couple minutes later, you told Mr. Marshall that he failed to signal, but the stop was for the tag light, correct?
Correct.
Never said anything about a California stop at that point, correct?
Correct.
And never said anything about the allegation that he almost struck a vehicle.
Correct.
You told Mr. Marshall that he drove in a complete circle, correct?
Correct.
Then you told Sergeant Hanshaw that he drove in a square.
Correct.
Okay. So Mr. Marshall provided you with proof of insurance on his cell phone, correct?
Correct.
Was that valid insurance?
It was.
Okay. And do you recall testifying on September 5th that Mr. Marshall handed you a debit card?
I did.
Did that happen?
No.
How in the world do you testify that this defendant handed you a debit card when that fact didn't exist?
that was misjudgment on my part. I messed up on that part.
So, you told Mr. Marshall that his eyes were glassy, and you asked him how much he had to drink tonight, correct?
Correct.
And do you believe that your body camera footage shows the glassy eyes?
At one point.
Okay. Do you know what, I mean, without telling me a time, is there a specific point in the encounter that you believe it captures that?
Whenever I asked him for his name and date of birth, and he glanced up at me.
Okay. Do you know how the condition of Mr. Marshall's eyes were different on this occasion than on any other occasion? You've never seen his eyes before, correct?
Correct.
And glassy eyes caused by a bunch of different things, correct?
Correct.
And according to NHTSA, I'll be happy to show it to you, the presence of glassy eyes is not a clue of alcohol consumption or impairment or drug consumption or impairment. Do you agree with that?
Correct.
Okay. So what's the significance then of you talking about his glassy eyes?
The fact that I seen an open case of Bud Light in the back of the floorboard of the car, and it had an odor after we opened the car. After we had him step out, there's an odor that came out of the car.
But none of that has to do with glassy eyes, correct?
The alcohol consumption for that, it would be an indication of that.
Okay, what I'm asking you is, are you familiar with the clues that NHTSA has for when you make personal contact with a subject?
I'll say I haven't been brushed up on it recently, no.
Okay. I'm going to mark Defendants Exhibit A. May I approach him, Your Honor?
Yes.
Deputy Frank, I'm going to show you Session 6 out of the February 2023 NHTSA manual and just have you take a look at that. Specifically, I'm going to have you look at page 5. And do you see the list of indicators of impairment in the personal contact phase?
Right below the list, the bullet points.
Yes, sir. Do you see them? And bloodshot eyes is on there. But my point is, glassy eyes is not one of NHTSA's clues, correct?
Correct.
Okay. And I think you told Mr. Heald that Mr. Marshall's eyes were almost bloodshot.
Yes.
And you never at any point in this encounter, when you were speaking to Mr. Marshall, Sergeant Hanshaw, or Trooper Sullivan, did you ever tell them that you thought Mr. Marshall's eyes were somewhat bloodshot?
No.
Today is the first day you've told that to anybody, correct?
Correct.
You and Mr. Heald talk about whether or not there was bloodshot glassy eyes when you met with him?
Do not.
Okay. And at no time do you claim to have smelled the odor of an alcoholic beverage from Mr. Marshall's person. I understand the car.
Correct.
Okay. And you radioed for an OSP unit for a possible .19.
Correct.
.19 is OVI. Okay. And why request the post?
Because we don't normally conduct OVI traffic stops. We usually hand those over to OSP.
Is there a reason?
We don't have the like a PBT test to test it. And normally we don't usually do traffic on certain things regarding traffic stops.
So it's your testimony, is it the policy of the Lawrence County Sheriff to hold these people for the post?
Not more than likely, yes.
Okay. And Mr. Heald asked you some questions about Mr. Marshall being somewhat slow to respond to you, correct?
Yes.
Did you ever ask him if he had a hearing problem?
I did not.
Because doesn't it appear that unless he's facing you, he's not interacting with you?
That's correct.
Okay. And Sergeant Hanshaw arrived on scene about approximately 1 minute and 37 seconds into the traffic stop, is what I believe. Does that sound about right?
About right.
Okay. So at this time, you're stopped in a well-lighted parking lot, correct?
Correct.
And there's multiple officers on scene?
Correct.
One on the way?
Correct.
Okay. And you ordered Mr. Marshall to exit his vehicle, and that was based on his eyes and his failure to identify himself, is what you told him, correct?
Yes.
And after you told Mr. Marshall to exit the vehicle, did you see on the video where he's reaching for his wallet and you tell him, no, we're past that, exit the vehicle?
Yes.
So you agree that he was attempting to get in his wallet at the time you were ordering him out?
No, I don't believe that he was reaching for his wallet. I didn't know what he was reaching for. I just told him to exit the vehicle because I didn't know if it was a weapon and it was for officer safety.
His wallet was in his back pocket, correct?
Correct.
His wallet had his ID in it, correct?
Correct.
Okay. Then what were you meaning when you told him we're past that? Past what?
Him trying to
Identify
himself finally.
Right. So you did know that's what he was attempting to do when he reached in his pocket? Or you wouldn't have known, if you thought he was grabbing a gun, you wouldn't have said, we're past that. You knew he was trying to identify himself.
Trying to stall from getting out of the vehicle.
Okay. When he exited his vehicle, you didn't observe any balance issues during the exit sequence, correct?
Correct.
You remember testifying on September 5th? Remember testifying that he swayed at some point when he got out of his car?
Yes.
It's not on the cam, didn't happen, right?
Unless it was when he stepped out of the vehicle initially.
Okay, but you don't recall that now? So would that be the second thing that you testified to on September 5th that we now agree was not true?
Yes.
You also testified that Mr. Marshall tensed up after exiting the vehicle.
Place the handcuffs, yes.
And the judge has seen that video. You didn't have to give Mr. Marshall any additional instructions about putting his hands behind his back. You told him one time, correct? So he didn't put up any resistance to you, did he? And at that point, the decision had already been made that he was going to be handcuffed, put in the back of the cruiser, and held for the state patrol. Right?
Yes.
So that the fact that you claim he tensed up, you didn't alter your decision-making whatsoever, correct? Now, when Mr. Marshall exited his vehicle, you told him 3 times to put his hands on the hood of the car. Recall that?
Yes.
You meant the roof of the car, right?
Yes.
You were giving him a command he couldn't possibly follow, correct?
Yes. Again, that was my mess up.
And you conducted, in response to Mr. Heald's question, you conducted a search of Mr. Marshall's person, correct?
I did.
Was this a search incident to arrest?
No, it was a search incident for officer safety and detention while he was in the back of the cruiser, because we've had instances of people having drugs and whatnot when their hands are placed behind their back. They have drugs or other things, foreign objects hidden on their person that we can't feel in the pockets that they later end up somehow consuming, and it could cause a harm to themselves or officers.
Do you agree you removed a box of condoms from Mr. Marshall's right front pants pocket?
I believe, I don't recall, maybe at one point.
Put your hands on the court. You got a chance to go totally fairly statement? I'll say, keep your hands up there.
What came out of his left pocket? Is that his pocket knife?
I believe that was a pocket knife, yes.
I believe it is.
22 notes, 4 seconds. Put your hands inside. Put your hands on the hood of the court. Go ahead, put your hands on the hood of the court. Turn around. Put your hands on the hood of the court. You got a chance to go totally fairly statement?
And Mr. Marshall volunteered the location of his pocket knife, correct?
Right.
I'll say, look, you guys up there.
Is that the box of condoms? Okay. And then, you didn't believe that box of condoms was a weapon, did you?
No.
Okay. And you removed Mr. Marshall's wallet from his pocket, took possession of it, correct?
Correct.
You didn't think that wallet was a weapon? Okay. And you also seized Mr. Marshall's cell phone, correct?
Correct.
That clearly is what it is. When you arrest somebody, you don't allow them to keep possession of their phone, do you?
No.
And you never returned any of these items to Mr. Marshall. They were given to the trooper.
Correct.
What was your legal basis? Is it officer safety for actually searching his person?
Yes.
And were you trained on the difference between a Terry frisk and a search?
Yes.
What's the difference?
The difference is out in the outer pocket, just no manipulation. It's a Terry frisk. A search is actual when the person's under arrest.
But you did a search in this case.
Yes.
And the timestamp on the video will show the time, but you cuffed Mr. Marshall behind his back and placed him in the rear of your cruiser.
Correct.
And the sole purpose of that detention was waiting on the OSP unit to respond.
And for the officer safety, so he, just in case if he try to cause a harm to himself.
You have any evidence, anything you can articulate as to what would make you think Mr. Marshall may have had any idea of harming himself?
No.
And you walked Mr. Marshall to your cruiser,
I did.
and you didn't observe any balance coordination problems when you guys took that walk?
I said not the time. I was also assisted him by his right arm.
And when you do make an arrest of a person, you handcuff them behind your back and lock them in the rear of your cruiser, correct?
And then Miranda's, yes.
Okay. And you also conduct a search after the arrest?
Yes, I'll do a thorough search again.
And those are the exact same things you did with Mr. Marshall?
Yes.
And you interrogated Mr. Marshall about how much that he had to drink, correct?
Yes.
And Mr. Marshall told you he didn't know?
Correct.
And Mr. Marshall was being polite to you during this encounter, wasn't he?
Yes.
I mean, he asked you, could he please move the seatbelt over in the rear of the cruiser, correct?
Yes.
At the time that you locked Mr. Marshall in the rear of that cruiser, you knew his identity, correct?
Yes.
And at the time you locked him in the rear of the cruiser, had you already concluded that he was operating a vehicle under the influence?
I did not.
Okay. Then what did you mean, Mr. Hill asked you some questions about when you all were walking, Mr. Marshall made a statement about his job and you told him, well, so does driving under the influence of alcohol would also have an adverse effect on his job. Do you recall that?
Drinking and driving. Yeah.
But you're telling me you hadn't concluded that...
I hadn't concluded until the post got there. That was OBI.
You had not concluded until the post got there.
Yeah, I had made it out, had the determination, the final determination now.
He's more worried about placing this job. I said, you know this job? You know, I know what you do what they want you to do. Do what they want you to do.
Are you talking to Sergeant Hanshaw now about the effect of an OVI on his job?
I was.
But you're telling me that you hadn't concluded that he was OVI?
OVI, right. Drinking and unsafe, drinking and driving, that's one thing. But if you can't actually convicted of an OVI, it'll be different.
So at the time you locked him in the rear of that cruiser, you didn't believe you had probable cause to arrest him?
I did not.
Okay. Now, after you locked Mr. Marshall in the rear of your cruiser, you searched his vehicle.
I did.
Now, all of these aluminum bottles, they all had the cap screwed on, correct?
Correct.
Okay, so when Mr. Heald asked you if you could see those containers were open before you touched them, that was false.
The ones that were in the case.
We have the screw tips on.
Yes.
None of these aluminum bottles that we see none of those are without the screw top.
The one on the back of the car.
So it's your testimony that doesn't have a cap on?
I'll see it now. I'll see it's hard to see on the...
It has a cap, right?
Correct.
So the way you knew that those bottles were half full is you picked them up. And you could tell they were half full.
Pick that one right there. Correct.
Okay, so you're not claiming that any of these aluminum cans had the tops already off?
No.
Okay. So the only way you knew they were half full was by picking them up?
Correct.
Okay. And the only way you knew they were half full by picking them up was getting in Mr. Marshall's car?
Correct.
Okay. And he's not under arrest at this point. And there's nothing apparently criminal about those aluminum bottles with the top on until you touch them, right?
Correct.
Was this a vehicle search incident to an arrest?
Yes.
Okay. But you just testified that you didn't have probable cause at the time you locked him in the vehicle, right?
Correct.
I saw that you opened the driver's side door and seized the keys out of this vehicle. Correct?
Correct.
Because you've already determined that Mr. Marshall ain't driving away, right?
Correct.
While Mr. Marshall was in the rear of the sheriff's cruiser waiting on Trooper Sullivan to arrive, you did nothing to further this traffic stop, correct?
Correct.
Didn't write any citation?
Correct.
When Trooper Sullivan arrived, you told him that Mr. Marshall had a 15-pack of beer and 16 were half empty. Do you recall that? $12.45 on the counter. That's what I believe.
Possible 419 was he got a 15 pack, 16 half empty. That was half empty, there's one up front.
Okay, deputy, he didn't have a 15 pack with 16 half empty, did he?
No.
But you agree that's what you said?
I agree.
Okay. And you pointed to the beer with the top on that you'd seized from the vehicle, correct?
Correct.
And you opened the cruiser door to allow Mr. Marshall to exit, correct?
Correct.
So let me just summarize this. So when you first told Mr. Marshall that you told Trooper Sullivan that he almost hit the parked car, correct?
Correct.
Did you hear when Mr. Marshall asked Trooper Sullivan what would be the repercussions if he didn't take the standardized field sobriety test?
I don't recall.
Okay. I just want to, I'm almost done with this witness, Your Honor.
I can't call anybody that's heard that.
I'm going to move on. What would you have done if Mr. Marshall would have refused to perform field sobriety tests for Trooper Sullivan?
I say at this point, he was under Trooper Sullivan's custody.
So you'd have let Trooper Sullivan make the decision?
Yes.
Okay. That's all the questions I have.
I don't have any other questions of this witness, Your Honor.
You may sit down, sir.
Would we be able to have a short conference?
Sure.
In chambers?